Billy Ray saves the day. No, not a movie with Eddie Murphy. A federal judge, William Ray, who sits in the Northern District of Georgia, Atlanta Division, a Trump appointee at that, has just quashed the subpoenas by the Department of Justice, which they claim to have been issued by a grand jury, although the judge was not so sure, doing some sort of criminal investigation into the 2020 election, which is beyond the statute of limitations, seeking voter data, no, not voter data, election worker data of emails, phone numbers, and contact information of just people doing their civic duty, counting ballots, working at mobile sites and the rest. And this judge said no. He's not allowing that, and reminded the Department of Justice that while the grand jury is of the people, it is supervised, it is administered, it is regulated by district court trial judges like him, and he has shut the door as a gatekeeper. I'm Michael Popok. You're on Legal AF to kick off Wednesday morning. Let's get to where we are with this case. Now, let me just explain two different cases so I can clear up any confusion. The Department of Justice went in on a search warrant and seized several months ago about 600 boxes and equipment of voter data, and that was approved. And the subpoena, the search warrant that was executed, was not quashed or blocked by another federal judge who was also appointed by Bush, named J.P. Booley. That was that case. That was then. This is now. And in the now case, and I'll post this order, Fulton County Board of Registration and Elections versus the United States of America, that's been assigned to Judge Ray. Judge Ray, the issue before him is whether subpoenas issued by the grand jury seeking the name, or at least for the prosecutors, seeking the name, rank, and serial number, phone number, and email of election workers would survive. And he said it wouldn't. But he goes further, as most judges do in our current environment. Here's what the information sought was like. They wanted the name, phone number, emails, personal telephone numbers for individuals assigned to review mail-in ballots, whoever was assigned to the voter review panel or board, whoever was assigned to mobile voting locations, who tabulated votes, who volunteered to recount, everybody. The judge said, no, we're not giving out that personal information because there's a hunch, or as he said in one of his footnotes, that the Department of Justice said, some of the votes we looked at look suspicious. I don't know why I'm using a goofy voice from Disney, but that's kind of how the judge wrote it. Here's what the judge ruled. We start on page 5 of his order. In these hyper-political times, Judge Ray writes, in which we currently live, there are sure to be some who disagree with this decision because they believe the allegations of fraud in the 2020 election and believe that light should be brought to those claims. But a couple points are in order. First, nothing prevents a continued inquiry into those allegations, such as Congress and perhaps even the Department of Justice. It's just that the power of the grand jury, which exists to investigate potential crimes and to bring viable indictments thereof, cannot be used as their tool to do so. Second, and relatedly, that this result is fitting is clear if one considers the alternative. Otherwise, anyone in power, perhaps the next administration of a different party, warning, could use the grand jury process similarly to subpoena personal information of citizens or their political opponents with no legitimate law enforcement purpose. The information sought here, names, addresses, phone numbers, emails, is private and sensitive, so much so that should a private company fail to protect such information from electronic thieves, such company would most likely be sued in a data breach class action lawsuit. Thus, everyone, whether you support the president or you do not, whether you believe the 2020 election was fair or you believe it was not, should be concerned about the Department of Justice's ability to utilize the power of the grand jury to appropriate your private information without a legitimate purpose. So true, Judge Ray, so true. And here's a couple of footnotes. I always love the footnotes, dive into them. While I'm diving, take a moment, hit the free subscribe button here on Legal AF YouTube. We just crossed 1.16 million subscribers, all because of you. This is what it says in footnote 2 about the need for this information, because that's the burden that the government, the Department of Justice has in order to support a subpoena issued by a grand jury. We've got a series of judges, including the chief judge in Minnesota, who just quashed a series of subpoenas by the Department of Justice, claiming or ruling that they were done for political animus purposes to get back at Donald Trump's political enemies. That was Chief Judge Schultz. Okay. So what we're watching is a grand jury so corrupted that I've now come to refer to it as a wholly owned subsidiary of the Trump organization. There's no independence. There's no desire to be independent. That's what Todd Blanche, when he's up for his confirmation hearing next week, he's going to have a lot of explaining to do, including why there's just a series of quashed subpoenas, grand juries who have rejected indictments, judges who have dismissed indictments, findings of vindictive prosecution under Donald Trump / Todd Blanche's leadership. Why? And what does it say about his fitness, Todd Blanche, to serve as the Attorney General? Here's what footnote 2 says back to the order by Judge Ray. To be clear, no evidence has been presented to the court that the actual grand jury in the Northern District of Georgia seeks this information. In other words, that the grand jury said, I'd like to see the names of these people, as opposed to, and here's where he does a little carpetbagging pot shot at who's been brought in to try the case, as opposed to the out-of-district prosecutors who the DOJ has appointed to lead this inquiry, who have served this subpoena in the name of the grand jury. So he's like, I'm not blaming the grand jury. I don't think they did it. I don't think they asked for this information at all. Footnote 4, I also found very illuminating. It says on page 5, the DOJ argues that it has a legitimate interest in investigating potential criminal actions in the years that followed the 2020 election, including an alleged failure on the part of Fulton County. This is what we're talking about. Fulton County, Georgia, the most populous county in Georgia. It's where Atlanta is located. It's blue. It's dark blue. Is there a deeper shade than dark blue? It was never going to go for Donald Trump. He lost Georgia because there was an overvote, not of illegal votes, just there was a lot of votes that came out for Joe Biden in Georgia. However, the judge says, goes further. It says, including an alleged failure on the part of Fulton County to preserve its ballot images from 2020 for the time required by law. Such an alleged failure to preserve records arguably would not be barred by the statute of limitations. So all these crimes are barred by statute of limitations. If they failed to preserve the records, maybe that's not barred. However, the court says the DOJ also alleges, without proof to the judge, that a certain number of the actual 2020 ballots that it seized pursuant to a search warrant look suspicious. And ain't going to do it to support or to oppose a motion to quash. And I think the judge's words here ring true. Everyone, whether you support the president or you don't, whether you believe the 2020 election was fair or you believe it wasn't, you should be concerned about an out-of-control Department of Justice weaponizing its powers under the grand jury to seek your private information. Now, he goes through another 18 or 20 pages about using the United States Supreme Court decisions that have to do with this type of subpoenas. And he says the need, for instance, page 16, the need for subpoenaed information is low. The federal grand jury serves two primary roles, sometimes referred to as the sword and the shield functions. He says on page 16, the judge, a grand jury has broad subpoena power, which gives it authority to compel the testimony of witnesses, thereby assisting the prosecutor in the investigation of crimes. This is the sword function. Then, after the evidence is gathered, the grand jury votes on whether the prosecutor has enough evidence to justify charging someone with a crime. That's the shield. The primary purpose of any grand jury, the judge writes, is to determine whether a crime has been committed. That is the basic purpose. Importantly, the Supreme Court has made clear that a statute of limitations is usually considered the primary guarantee against bringing overly stale charges. As Fulton County lays out in its briefing, the applicable 5-year statute of limitations has run on any alleged crime related to the 2020 election. Page 18. Since Congress certified the electoral results at 3:44 a.m., the morning of January 7th. Oh, I wonder why they were so delayed. Did something happen on Jan 6th at the Capitol, led by Donald Trump? Since the Congress certified the electoral results at 3:44 a.m., the morning of Jan 7, the 5-year statute on any crimes ran on Wednesday, Jan 7, 2026, which was 6 months ago. So now, of course, the Department of Justice doesn't like this result. They've already issued the press release. Oh, one district court judge has ruled improperly that there may have been a running of a statute of limitations, and therefore we don't get the information we're seeking. He's wrong. Not going to work. Here's how the judge ends it. Page 27. The subpoena power of the grand jury is broad but not absolute. If it were, the Supreme Court could simply say so, which it has not. Given the low need for the subpoenaed information and the highly burdensome nature of the disclosure, it must be quashed. He then quashes it, says Fulton County is under no obligation to comply, and he's closed the case. Now, he is supervising this grand jury. And if they try it again, I think they're going to get William M. Ray II, Billy Ray II again. This is a sign that even in Georgia, even with Trump-appointed judges, there's a gatekeeping function that district court judges take seriously and that makes sure that our rights of privacy and that the Department of Justice's rogue tendencies are checked. And that's what we want courts to do. I applaud William M. Ray for doing what he did. We'll follow what happens next. The court above him is the 11th Circuit Court of Appeals. It sits in Atlanta. It covers Georgia, Florida, and I think Alabama. There are many judges on that panel that are chaired by William Pryor, who have a lot of experience with this Department of Justice and with Donald Trump when he was a criminal defendant. We will see what the 11th Circuit does. It leans a center-right. It's a center-right leaning court. But I think they're going to have a hard time, and I don't think William Pryor, the chief judge who would normally get a case like this, is going to find and overturn the ruling of Judge Ray. If he does, you'll be the first to hear about it. If they don't, you'll know about it on Legal AF, Substack, and this YouTube channel. Thanks for being here. Hit that subscribe